Welcome to the Explainer. Today we are unpacking a really fascinating area of the law that honestly most people completely ignore right up until life goes wrong. We are looking at the mandatory, hidden legal mechanisms that literally force property to change hands. We usually think of property transfer as this nice, cooperative handshake between a willing buyer and a willing seller, right? You negotiate, you agree, you sign the papers. But today, we are looking at the exact opposite. We're diving into involuntary transfer. This is what happens when the law compels you to hand over the keys because of circumstances that are just completely beyond your control. It totally overrides the free will of the original owner. To demystify these heavy legal mechanics, we've broken this explainer down into 5 clear sections. What is involuntary transfer? Court attachment and auctions, bankruptcy and liquidation, joint tenancy and survivorship, and finally, death and sole ownership. Let's get right into it. Section 1. What is involuntary transfer? So, what actually triggers these drastic legal mechanisms? Well, we're looking at major life events where property is transferred strictly by operation of the law. Things like death, where a succession process has to take over, unpaid debts leading to court attachments and auctions, corporate failure leading to bankruptcy and liquidation, and even compulsory acquisition. In all of these scenarios, the law steps in and forces the transfer, entirely without that mutual cooperation you'd see in a normal, everyday sale. Moving on to Section 2, Court Attachment and Auctions. It's actually fascinating how the law acts like a giant gavel to enforce unpaid debts when people stubbornly refuse to pay. When a judgment debtor drags their feet and dilly-dallies on paying what the court ordered, the escalation is seamless, and honestly, it's ruthless. It moves from a simple notice to show cause straight to warrants of attachment. If they still don't pay up within that 14-day notice period, a proclamation is issued, and it all ends at a public auction where the hammer falls on the highest bidder. So here is the million-dollar question. Once the highest bidder pays, how do they actually get the property if the original owner is sitting there, holding on to the title deed, and flat out refusing to sign anything? Well, the answer is a vesting order. This court order completely bypasses that uncooperative original owner. It officially declares their old documents completely invalid and allows the court's executive officer to legally sign the transfer paperwork on their behalf. Problem solved. But listen, here is an absolutely critical warning if you ever buy at an auction. You have to protect your purchase by placing a caveat on the property immediately. Seriously, do not wait. An auction transaction can take up to 90 days to close, and a bidder, original owner, might still be physically holding their old, now invalid title. They might try to use it to illegally sell the property and defeat the execution. So a caveat just firmly locks them out. Section 3. Bankruptcy and liquidation. Let's move over to the ledger and see how this builds when we contrast natural persons with corporations facing total financial ruin. These are 2 insolvency concepts that people mix up all the time. Bankruptcy is strictly the legal term for natural persons, individuals. When an individual goes under, a receiver or trustee is appointed. But when we're talking about a juristic person, like a major corporate entity such as Safaricom or Asako, the proper term is liquidation. And in that case, a liquidator takes over, using entirely different legal forms to transfer the property. It is absolutely vital to understand that once liquidation orders are made by the court, stubborn company directors completely lose their voice. It's game over for them. Under Section 64 of the Land Registration Act, they literally have zero role in property transfers anymore. All of that power shifts instantly, right to the liquidator. There are some pretty well-known cases where defiant directors try to act aloof and postpone the inevitable, just wasting time and money. But as they say in the legal world, the wheels of justice grind slowly, but they surely grind. You can play monkey business all you want, but eventually you are going to hit a dead end, and the liquidator is going to execute their mandate regardless of your defiance. To actually execute these involuntary transfers, the liquidator can't just do whatever they want. They must strictly follow the Companies Act and provide verified documentation. We're talking about presenting a certified court order proving the directors are fully out of the picture, alongside a declaration of compliance. Plus, they have to sign the transfer form L-48 using their official designation as the liquidator. Let's dive into Section 4, Joint Tenancy and Survivorship. So what happens to co-owned property when a partner tragically passes away? Well, it's highly important to contrast the 2 ways you can co-own property. If you own property as tenants in common, you own separate, distinct shares. If you fall out, it takes a really complex legal partitioning to sever that asset.
But joint tenancy is a totally different beast. It triggers an automatic, seamless legal mechanism the second one owner dies.
You can use the intimidating Latin term just a crescendi to impress your friends at dinner, but it's really just the legal doctrine of survivorship. It simply means the surviving joint owner automatically gets the entire property absolutely. It does not become part of the deceased's general estate to be fought over in probate court. It just passes right over. Because so many people are unaware of this, they mistakenly throw this joint property into the deceased estate, which creates a massive, unnecessary headache. They don't realize they simply need to file Form L38 with the land registry. You just attach a certified death certificate, your IDs, surrender the original title, and the registrar simply deletes the deceased name from the register. Boom. It's a mandatory transfer by operation of law.
Finally, we arrive at Section 5, Death and Sole Ownership.
Now we're exploring the forces of the grave when a sole owner passes away, leaving a property entirely in their own name. When dealing with a sole owner's estate, the rules are incredibly strict. The property cannot just be handed out to family members. It must legally vest in an executor or administrator via a confirmed grant of probate or letters of administration before it can ever be transferred to an heir.
Let's do a quick thought experiment. Imagine you are reviewing a property title presented by someone claiming to be the administrator of an estate. You look at the document and you see the property is just in their personal name. It explicitly misses the legally mandatory words, as executor of the will of, or as administrator of the estate of. So what do?
I'll tell you what you do. You run. That is a massive red flag indicating profound fraud. The law mandates that the title must clearly show they hold it on behalf of the estate. If those exact words are missing, like Pontius Pilate, you must wash your hands of that transaction immediately and absolutely refuse to proceed. No exceptions.
This leads us right into the wild cautionary tale of wash property laundering. This sneaky process happens when corrupt administrators deliberately omit a property from the official estate schedule. They collude with an unethical advocate and illegally transfer the title into their own personal name. Then, they quickly try to sell it to an unsuspecting third party, hoping the new buyer can just hide behind the legal defense of being an innocent purchaser for value without notice.
But, as our source material brilliantly illustrates, that innocent purchaser defense, it is not going to save you if you buy a laundered property. The courts rule very clearly that once a bad title, always a bad title. The property will be clawed right back to the estate, and if you bought it, you are going to be left completely empty-handed, forced to chase down the fraudulent sellers for a refund. And good luck with that. Wow, we have covered some incredible ground today, looking at how the law relentlessly forces the transfer of property during auctions, insolvencies, and deaths. So knowing what happens when the law forces your hand, what steps will you take today to ensure your assets are legally structured so they don't fall victim to these hidden legal mechanisms? Really think about that. Thanks for joining us, and we'll see you in the next explainer.